This is the throwback to the European socialists who founded Israel, and Israel has moved to a much more conservative position, culturally, politically, socially, when it comes to its foreign policy, and they are resisting this. And they are using the courts to resist the people of Israel.
This is where freedom reigns.
If you believe in America, if you believe in the Constitution empowers us. It's a new day. America's back. America's back, and America's going to get strong again. We're going to defend America, and we're going to defend our interests.
Liberty's voice, LevinTV.
Hello, my friends. I'm Mark Levin. This is LevinTV. This is a very, very special program where we're going to focus in on our closest ally, Israel, and its relationship with the United States. But first, the Prime Minister, Benjamin Netanyahu. The Prime Minister of Israel and the President of the United States are very close. They've accomplished many, many things together, both for the United States and the State of Israel. Absolutely unprecedented in my view. And we've seen in Israel multiple elections now, where the party structure there makes it very difficult to cobble together a majority in the Knesset and to appoint a prime minister. But every poll has shown that I've seen that Benjamin Netanyahu is the most popular of the people who runs for the position of, technically, of prime minister. Now, that said, finally there's a coalition government that's been put together. There's a deal that's been put together between Benny Gantz and the Prime Minister Netanyahu. It's taken a lot of work, it's taken a lot of time, and if it had failed, there'd be yet a fourth election. In the middle of the coronavirus pandemic, in the middle of Iran threatening Israel, and all kinds of great problems that the people of Israel face. And so finally you have this coalition that's been pulled together, very specific and detailed agreement that they've reached, and now lawsuits have been filed in Israel to try and prevent the coalition, challenging the deal, challenging the ability of Prime Minister Netanyahu to continue in that post for the next 18 months under the deal. And the Supreme Court of Israel is taking up all these issues. And the reason I think this is important is because in the United States we have a Supreme Court too, and we have what's called, I think, the political doctrine, that basically we leave it to the branches to duke it out. As best as possible, the courts try and stay out of politics. Not so much in Israel. In Israel, it seems like the opposite is occurring. And I wanted to bring on the program one of the great legal minds in the United States, and quite frankly, Israel too, a man that knows the law backwards and forwards in both countries. Nat Lewin, how are you, sir?
Very well. Thank you, Mark, and thank you for that introduction.
Well, it's a great pleasure. You and I become friends. I admire you. You've been involved in many, many significant Supreme Court cases in the United States. You represented a former boss of mine at one time, the Attorney General of the United States, and with me, a wonderful man. And you've been involved in legal activities in the State of Israel as well. You spent a lot of time there. You have a home there as well. First of all, let's walk through this. The authority of the Supreme Court in Israel seems to be an exception to virtually every civilized democratic country on the face of the earth. What is the Supreme Court in Israel like, and what kind of powers has it assumed?
Well, the Supreme Court of Israel, its membership is 15 justices, by the way. They usually sit in panels of 3, sometimes 5 in important cases, but they have extraordinary authority because, quite frankly, Israel is a very law-abiding country. And whatever the Supreme Court says, a large part of the country, an overwhelming majority, says, well, that's the law, we have to follow it. And consequently, it's the Supreme Court that sets its own boundaries. In the United States, the Supreme Court is very sensitive to the fact that there are questions which are beyond the power, beyond the scope, beyond the expertise of the Supreme Court. And therefore, there's a political question doctrine. The Supreme Court of the United States has always, just centuries, really from the very beginning, recognized that it had limitations on its own power, notwithstanding the rule of Marbury versus Madison, that the Supreme Court could decide whether a law is constitutional. Nonetheless, the Supreme Court has set certain limits on the powers of courts in the United States, and certainly federal courts and its own powers. And some of those questions are questions of that lawyers call justiciability or political question. I had the privilege of arguing probably what was the most recent time that the Supreme Court of the United States had before it a question of justiciability or political question. That was on the issue of whether a law that said that an American citizen born in Jerusalem had the right to have Israel in his or her passport. The lower courts had said, well, that's a political question because it involves foreign policy. We took that to the Supreme Court. I argued it, and the Supreme Court, looking at the political question doctrine, said, no, that's not a political question. That's a question of whether the Constitution has authorized Congress to pass such a law. They sent the case back. Unfortunately, the lower court said, okay, we think it's unconstitutional for Congress to do that. The Supreme Court, by a 6-3 vote, agreed with the lower court that it was unconstitutional. Then because they said only the president can decide whether Jerusalem is in Israel. Those justices in the 6 who said that never remotely anticipated that there would be a president of the United States who would actually come into office and say, yes, Jerusalem is not only in Israel, but it's the capital of Israel. Along came Donald Trump and said, Jerusalem is the capital of Israel. And now, very happily, we have a U.S. embassy in Jerusalem. Well, nobody has challenged that. They've taken everything that President Trump has done to court, but nobody has challenged his decision that Jerusalem is the capital of Israel, because 6 justices of the Supreme Court said in our case, in a case that my daughter argued in the Supreme Court when the case came up the second time to the Supreme Court, that that is the exclusive prerogative of the President of the United States. So there came the president, he said it, and everybody has to accept the fact that Jerusalem is the capital of Israel. Nobody else in the world.
So Nat Lewin, that's the U.S. Supreme Court, which is very mindful of boundaries, as you point out. Take a look at the statute, take a look at the Constitution, whether it's a political question. They try to avoid political questions. They even noodle over whether something is a political question to determine whether or not they have jurisdiction. So they police themselves. The courts actually police themselves, particularly the Supreme Court.
Yeah, let me just note on that a very interesting point, which is just last week, just a very short time before we'll hear arguments in the case, the Supreme Court initiated a question of whether the issue in 2 cases that are coming up before the Supreme Court in which President Trump has challenged subpoenas for his tax records. Cases were decided by the Court of Appeals in New York and by the Court of Appeals in the District of Columbia. They're up before the Supreme Court. There have been hundreds of pages of legal argument filed in the Supreme Court. They're going to hear argument on that case in 10 days. And the Supreme Court suddenly issues an order and says, tell us in a letter, please, to the parties, is this a political question? The Supreme Court on its own has asked whether its power is limited in a case because it will affect the coming election. It seems to be a battle between Congress and the president. And the Supreme Court says maybe it's not the court's business to decide those questions. So the Supreme Court on its own has said we recognize our limitations. On the other hand, in Israel, particularly since there was a president of the Supreme Court named Aaron Barak, who was a great legal scholar, brilliant fellow, but when he became president of the Supreme Court of Israel, he very proudly got the court to agree that there were no limitations at all on the power of the Supreme Court of Israel. Ordinarily in the United States, a party has to have standing. You have to be hurt by what has been done in order to allow you to go to court. A case has to be justiciable, has to be not a political question, not a question beyond the power of the court to decide. Aaron Barak very proudly said, we don't believe in any of that. Anybody has standing. Cases don't have to be justiciable. It doesn't have to be a political, we can decide political questions. And therefore, what is now before the Israeli Supreme Court are 5 petitions filed not by opponents, not by anybody who says, look, I've got standing, but just people, groups that say we're opposed to having Netanyahu as prime minister. And in Israel, there is no rule of standing. Anybody can come before the Supreme Court and say, hey, we're a group that opposes Prime Minister Netanyahu, and we say he should not be in office. So there's no rule of standing. There's no limitation because Chief Justice Barak said very proudly, we're getting rid of rules of standing. We're getting rid of the principle.
Well, Nat Lewin, let me ask you a question. Doesn't this open the door wide to the politicization of the judiciary in Israel? I mean, justices may say, no, we're going to decide on the law, we're going to decide on the facts. But isn't the reason the Supreme Court takes a different view is because they want the court's decisions to be respected and understood as best as they feel they can, as really at least an attempt at an objective interpretation of the United States Constitution or some statute. Doesn't that undermine the throwing the door open to any case that anybody wants to file? Because a lot of cases are political. They are motivated for obviously partisan reasons. Doesn't that kind of diminish the reputation of the court, not just among professional lawyers who have to deal with these courts, but with the people generally? They may follow the law because the law is the law, but they may say, wait a minute, what's this? Why is this court intervening in a political process? I just voted. And now we have 15 justices, or really a subset of 15 justices, who are now going to decide for me what our government's going to look at, who the prime minister is going to be, whether or not the Knesset passes a law related to this, whether the information or elements of that law are correct, and so forth and so on. I want you to answer this question when we come back, because I think this is a fundamental issue. We'll be right back with Nat Lewin. Welcome back. Nat Lewin, let me focus in. So the court really can consider anything at all, based on what you're saying and based on what it's doing. The legitimacy of a deal between coalition parties, the legitimacy of an election of a prime minister, even though there's not a law that says if you're charged you can't serve, the legitimacy of statutes passed by the Knesset, or the court saying we're going to look at these statutes passed by the Knesset to institute the deal. Some people might say that's like a Politburo. That's an awful lot of power with the 15 justices and a subset of that overseeing the Knesset, overseeing what the prime minister is doing, overseeing what the parties are doing. What says Nat Lewin?
Well, clearly that is an excessive delegation of authority to a group. In this case, there are 11 justices of the Supreme Court who are hearing it. And as a matter of fact, they recognized during the oral arguments of the case, the justices, even the activist justices of the court, recognized that what the advocates were arguing for when they said that Netanyahu should not be prime minister were sort of populist arguments, were arguments that were being made not on the basis of the law, but on the basis of some general feeling that maybe this wasn't right. Now, they recognize that. The fact is that even the man who charged the prime minister, the attorney general, Mandelblit, and I had the privilege when I was in Israel on my last trip of arguing before Attorney General Mandelblit that Prime Minister Netanyahu should not be charged with a crime. I sat in a room with Attorney General Mandelblit and a whole bunch of associates of his, all of whom the associates clearly wanted to charge Mr. Netanyahu with crimes. I presented the argument as to why it should not be done. Nonetheless, Mr. Mandelblit did charge him. Now, there's an important difference between a charge in Israel and a charge in the United States. And in the United States, it's in the Constitution. Many people don't realize it today, but the Fifth Amendment to the US Constitution starts with an instruction that no one is to be charged with a felony. The word felony isn't used, but no one can be charged with a felony in the federal system, and I think it should be true in the state system as well, except upon indictment by a grand jury. It's not a single prosecutor who goes out and can charge somebody with a federal crime. In Israel, it was Mr. Mandelblit and his 24 associates who were sitting there in the room with me. They wanted to charge him. When I was with the Civil Rights Division of the Department of Justice in the 1960s, and we wanted to charge police officers who were treating blacks badly and improperly in violation of the Civil Rights Act, we had a hard time getting indictments before grand juries. I was very proud when I went to New Jersey and I managed to get some local police officers indicted. It was a hard time before a grand jury in those days in those kinds of crimes. And I bet that if there were a grand jury requirement in Israel today, Netanyahu would never have been indicted for any crime in Israel. It was only because the Attorney General himself charged him. Now along comes the Supreme Court and says, and it's interesting that Mr. Mandelblit told the Supreme Court, don't prevent Netanyahu from becoming prime minister. And he's recently even told them, don't do anything which will invalidate the agreement between Netanyahu and Gantz. Now, that's the ultimate political question. You would think in the United States, if there was an agreement between the Democrats and the Republicans as to what to do, how to get a bill passed, the Supreme Court would keep its hands out of that. They'd say that's a political question. In Israel, before the Supreme Court, are 3 petitions to invalidate the agreement between the parties, between Gantz and Netanyahu. They don't like some of the provisions. And the Israeli Supreme Court was able, during the argument, to get the representatives of Likud and of Blue and White to agree during the argument that they would amend those political agreements. Now, that's extraordinary power for a Supreme Court to say, look, 2 political parties arrive at an agreement, and we're going to make them change that agreement because we don't think it's right that you shouldn't be able to appoint some senior officers during 6 months after you come into office. And yet, because of pressure from the Supreme Court of Israel, they've apparently agreed to do that. Now, we're recording this on a Wednesday. On Thursday, tomorrow, the Supreme Court is supposed to come out with a decision. And I don't know what will happen, what the Supreme Court will say tomorrow. But they've now been told by Attorney General Mandelblit, and certainly by the arguments that were made on behalf of both Likud and Blue and White, that they should not invalidate the agreement, the political agreement between those 2 parties. In the United States, it would be unheard of for those kind of issues to come before the Supreme Court of the United States because of standing, because of justiciability.
This is very concerning if you live in what you believe is democracy, whether it's the democratic form they have in Israel or the United States or any other free country, when a relative handful of people that the vast majority of the Israelis know nothing about, just as the vast majority of Americans don't know much about the Supreme Court justices, are second-guessing, third-guessing, however you want to put it, the outcome of an election. Now, the Israeli system is convoluted enough. You can win a majority and not get a majority, depending on minority parties. And we've seen this play out now over the course of several years in 3 elections. And then you have a president of Israel. It's a very unique system, who is sort of the referee trying to encourage them to come up with an agreement. And they're duking it out for weeks, if not months, over the course of years. They finally have an agreement. People make political decisions. Some make courageous decisions. Some put their careers on the line. And they come together and they work out a deal, how many ministers they're going to have, how many deputy ministers, who's going to serve how long, who's going to be the Speaker of the Knesset, and so forth and so on. So these are not rash decisions. These are decisions that are really ironed out over a course of time in a very complicated electoral process. I'm just saying, the idea that you're going to have 11 justices now who are going to sit there and now second-guess everything and go through everything means that the judiciary really isn't independent except when it issues its decisions. That is, it is eye deep in politics, eye deep in the electoral process. I'm not talking about civil rights issues or anything of the sort, on outcomes and so forth. Do you think the Supreme Court of Israel at any time in any way, that whole process, it can be reformed? Because you write this piece and you point out in 1995, basically one gentleman with the support of a few other justices changed the entire system. I can't imagine that this can go on forever like this. What's your thought on that?
Well, ever since Israel was established, there was hope that there would be a written constitution. As a matter of fact, the Israeli Declaration of Independence specifically foretold or said there would be a constitution that would be written. But it's been impossible to get a consensus on the kinds of issues that affect the law in the United States. And therefore, the Supreme Court of Israel has sort of been writing a constitution. And former president of the Supreme Court, Aaron Barak, he was viewed by very experienced judges in the United States as being an enlightened despot. They said, Bob Bork said of him that he was the ultimate in judicial hubris because he felt that there was no power that could be higher than the power of the Supreme Court of Israel. And I think it will take Israel enacts basic laws when there's a consensus in the Knesset and the Israeli Congress. They can enact a law that says that it will take effect like a constitution. Maybe that's the only way this can be done, by having a consensus that will say we limit the power of the Supreme Court. Because Israel, after all, is not a 3-branch form of government. We have, the founding fathers in the United States had the genius to set up a Congress, an executive, and a judiciary. Israel has a legislative system in which the Knesset is elected, and it then forms the executive. And there's a separate judiciary. In Israel, there is no elected president. The president is kind of the formal person who represents Israel in celebrations and has some ministerial duties, but no real substantial power as the United States has with an executive branch. So it will take a sort of constitutional upheaval in Israel to really be able to limit the power of the Supreme Court, which is now unbridled, really.
Well, Nat Lewin, I want to thank you very, very much for walking us through this. And I appreciate all the things you've done here in the United States and in the state of Israel in your illustrious career. And God bless you, sir.
Thank you.
We'll be right back. Welcome back. Our guest is Arthur Ferguson, who's quite renowned as a tremendous litigator, as a clerk on the United States Supreme Court for the former Chief Justice, Warren Burger, who served in the Department of Justice for a period of time, and has talked extensively about the charges against the Prime Minister, which he considers, and I do too, utterly and completely bogus. But I want to focus right now, Arthur Ferguson, on the Supreme Court. That's where the action has been. It's a very odd court, isn't it, in terms of Western civilization. First of all, it's incredibly political. It's incestuous. And it can upturn or turn over elections and coalitions and get involved in the negotiations. That is, deciding what is kosher and what's not kosher, if you will. What is your take on the Supreme Court of Israel?
My take on the Supreme Court is that because of this incestuousness, where the current Supreme Court has and had a veto power on new members, that this is the last gasp of the socialist Western European founders of Israel to preserve what they deemed to be an appropriate social policy over the desires of the Israeli people and the Israeli voters. They had no business doing this. It is dangerous. And although the court speaks and the good government petitioners to try to overturn the coalition, to try to overturn the will of the Israeli people, speak in terms of Israeli democracy, preserving the Israeli democracy, it is the antithesis of democracy when the justices of the Supreme Court intervene to prevent the demos, the will of the people, from being expressed. It is anti-democratic, and it is the last institution in Israel to preserve what the Likud and Benjamin Netanyahu and his supporters have changed. It is wrong, and it is bizarre. I think that if your listeners look at what the High Court is doing, the 11 justices, the president of the High Court, and the 11 justices are doing, is to interfere in how the coalition of Netanyahu and Blue and White seek to govern Israel. The nature of committees, the progress of appointments, what's going to be on the agenda. You know, Mark, in Israel, which has no constitution, the former Chief Justice, the president of the High Court of Israel, established a principle that once the legislature passed the laws, they couldn't be repealed. So that, and that justice, as interpreted by the court, in particular this chief judge, his name was Aharon Barak.
Yeah.
Thought, my pronunciation is a little shaky.
Yeah, but we're well familiar with him. He was our prior guest, Nat Lewin, was saying that Robert Bork referred to him as or he referred to himself as a benevolent despot. But anyway, go right ahead.
Yes, that whatever he deemed to be just or reasonable, sounds like something out of Spinoza, would be sufficient to invalidate laws, to change the composition of the Knesset's operations. And you asked me to look at the questions that have been raised.
Well, let me just pick up where you are.
Okay.
In effect, the Chief Justice of the Supreme Court is the most powerful political figure in the state of Israel. Not the most powerful legal figure, the most powerful political figure. Because no matter what the electorate decides, no matter what the parties decide, no matter what the Knesset decides, no matter if the Prime Minister and another party decide in a coalition how they're going to appoint their cabinet, their sub-cabinet, whatever it is, the Chief Justice of the Supreme Court and his cohorts have decided they can second-guess anything they want to.
On any basis that they want to, which basis is inside them. Whenever they deem to be just, or as Aharon Barak said, what is reasonable? If it's unreasonable, it's illegal. Can you imagine that? That is despotic. And he's not subject to elections.
So would you agree with me, Arthur Ferguson, that Israel really does have a judicial tyranny? That this is a tyrannical court that doesn't self-police, that doesn't know limits, like virtually every Supreme Court in every free country, certainly our country. We criticize activist judges, but they're nothing compared to what goes on in Israel. These justices are proud of their activism, and then they pretend that they're upholding the law. I just want to point out here, you pointed out, that there's this Judicial Selection Committee, which is really an insider's game. There are 3 current justices that sit on this Judicial Selection Committee, 2 appointed also by the bar, and this cabal of 5 controls the 9. And also, as I understand it, and I think you pointed out to me, since you need 7 of the 9 on the committee to go forth with a justice, to appoint the justice, after all the other bizarre activity takes place in the process, these 3 sitting justices have a veto, in effect, on who's appointed. Is that correct?
Yes, they do. So that there is no democratic check on the Supreme Court of Israel. It is something that we would find intolerable, and countries that value democracy and representative government would find intolerable. This is an antiquated, the dead hand of the socialist founders of Israel over the entire government structure of Israel. The language that they use, don't believe it. It comes right out of Animal Farm in 1984, where language is used when it means exactly the opposite. And that is what the Israeli court is doing. They are involving themselves in the details of a coalition agreement that avoided a 4th election.
Let me point out, no matter how this turns out, the fact is that this Supreme Court has doubled down on the politicization of the legal process, that these cases should never have been accepted by this court, that once these parties came together and formed the coalition government, they can do pretty much whatever they want. I mean, they can appoint whomever they want to whatever cabinet position they want. They can agree that one will serve this period of time, one will serve another period of time, as long as they follow what is the basic law of Israel, and they certainly have. But now you have the Supreme Court making what kinds of decisions, entertaining what kinds of decisions. Arthur Ferguson, when we return, this is what I want to pursue with you. What is it that they're focused on, and what authority do they actually have to focus on any of it? We'll be right back. Welcome back. Arthur Ferguson. So the court is focused on a number of things, but in particular, whether or not the Prime Minister is qualified to remain as Prime Minister in this deal because of the charges brought against him by the Attorney General. Now, they've been through several elections, including elections when he was charged, and now what? People vote over and over again, and the Supreme Court has a final say, even though there's no underlying law that prevents it. That's number one. Number two, they're delving into the specifics of the deal between the 2 parties, when senior officials can be appointed and so forth, and making judgments in lieu of and substituting their judgments for the political decisions of the 2 parties. What do you make of this?
The judiciary has become, the Supreme Court has become the body that is completely untethered from the will of the people of Israel, and can substitute its will for the people of Israel. And when two political enemies in Israel got together for the good of the country to establish a government. And as you pointed out, after multiple elections, 3 elections, and at a particularly difficult time for Israel, surrounded by enemies, but the opportunity to craft new friends, an economy that needs bolstering, and the coronavirus pandemic crisis. When they came together for the good of Israel, the Supreme Court, the High Court of Israel, comes in and says, I'm troubled by the role of the opposition in being on committees in Israel, what you're doing with that, or limiting the replacement of officials, high officials in government for a period of time, or of restricting the major policy decisions, except in emergencies, which the parties agreed to, for 6 months. We're only going to take up the questions on West Bank and coronavirus. And the Supreme Court said, I'm troubled with that. This is what the democratic elected parliamentary body based on the British system is going to decide to do. And they said, we don't want that. The justices, the questions that they asked. And so in an act of good faith, Netanyahu and Benny Gantz renegotiated elements that the Supreme Court had intruded into for their deal for the good of Israel. And okay, so the deal would now allow policy guidelines to be set on more than just West Bank and coronavirus for the first 6 months. The key appointments would only be done for after 100 days or be limited for 100 days, or sooner if a consensus is reached.
But your point, Arthur, is that the Supreme Court, the justices of the Supreme Court, after these two parties have negotiated, tedious meetings, negotiations, everything taken into consideration, the justices now have the final say, and they're passing judgment on technical details of an arrangement made up by two parties. They're passing judgment on whether or not the other party can be represented by the Prime Minister of the United States in effect. They're passing judgment on the outcome of the election, on whether or not they like it. And they have no legal authority. Even the basic law of Israel does not give this court the authority to do any of this. They have seized it for themselves, and they have exercised it irrationally and brutally over the course of the last several decades, and particularly now. And I want to circle back to your point. I think it's a brilliant point. This is the throwback to the European socialists who founded Israel, and Israel has moved to a much more conservative position, culturally, politically, socially, when it comes to its foreign policy, and they are resisting this. And they are using the courts to resist the people of Israel. Correct?
Correct. Under and untethered to any principle outside the internal values of the justices of the High Court of Israel.
Their personal ideology.
Their personal ideology. And I would urge your listeners, including your listeners in Israel, to read a review by Richard Posner when the New Republic had its book reviews that were honest and decent and open, that Richard Posner wrote.
A very famous federal appellate judge in the United States. Go right ahead.
Yes. And it's the title is Enlightened Despot. It's the review of Aharon Barak's book, and it's in 2007. Take it and read it. It's also valuable in looking at what the Supreme Court and federal judges do in the United States. Those on the left who arrogate to themselves the right to say what we should believe in, and who use their own value system, untethered to any limits, to establish social policy. This is valuable so that the people, as they express their views on the right or on the left or in the center, can find a way to have those expressed through the democratic process.
When we return, Arthur Ferguson, my question to you is this. What is the purpose of a judge, of a court, of a Supreme Court? And in Israel, has that purpose been upheld or has it been eviscerated, really highlighted today in the matter of Benjamin Netanyahu and this coalition government in Israel? We'll be right back. Welcome back. Arthur Ferguson, this Supreme Court, the job of a Supreme Court, the job of a judge. Why do we have judges in Supreme Courts in the first place?
Courts are designed, as we understand them, and as they should be in Israel, to provide an opportunity to make sure that the laws passed by the legislature are properly interpreted.
Well, isn't it also, Arthur Ferguson, to objectively adjudicate cases between two parties?
Absolutely.
To do so without an ideological, political mentality? For the Supreme Court to take up really only a handful of cases that really require the Supreme Court to get involved. That's a self-policing mechanism, show some restraint, not to be able to reach its tentacles in every aspect of society. Has this Supreme Court in Israel done that?
No, they have not. What they are doing now is, as you pointed out before, intruding into the details.
Do you have some examples of this court?
Sure.
Out of control?
Let me turn to Posner, so that the people in our country, in America, can understand how the Israeli High Court has gone far beyond the expected norms that we understand. And that the people in Israel who are watching this understand that the unfinished business of a changing Israel is to rein in and reform, utterly reform, the Israeli High Court. That has to be the effort, and I know he's going at it now.
All right, let's have some examples, please.
Richard Posner's wonderful review of Barak and evisceration of it. Among the rules of law that Barak's judicial opinions have been instrumental in creating that have no counterpart in American law, or the principles, as you point out, of what a judiciary should be doing, are that judges cannot be removed by the legislature. We, of course, have impeachment, but only by other judges. That goes to your incestuous point. That any citizen can ask a court to block illegal action by a government official, even if that citizen is not personally affected by it or lacks standing to sue in the American sense. So that, Mark, goes to your point that in Israel, the court can walk into any dispute as long as somebody files a petition. You file a petition, the judges get involved. So there is no self-limitation. That any government action that is unreasonable is illegal. But simply, quoting from Barak, the executive must act reasonably, for an unreasonable act is an unlawful act. No principles. We have a constitution. Whether it's reasonable or not in our system, as it should be in the Israeli system or any true democracy. The test of reasonable should be and must be for the legislature, because otherwise it's just how the judge is feeling, or to put it another way, what the judge had for breakfast. And I'm sure everyone in law school remember that.
Can the court get involved in military decisions?
Oh, yes.
Can the court get involved in foreign policy decisions?
Right. And that in the name of human dignity, quote unquote, a court can compel the government to alleviate homelessness and poverty, and that a court can countermand military orders, decide, quote, whether to prevent the release of a terrorist within the framework of a political.
So let's recap. So the court can get involved in social, domestic policy, in economic policy, always to the left, by the way.
Yes.
And can the court get involved in military decisions? Yes. I think the point we're trying to make to our viewers here, whether they be in Israel, the United States, or any other parts of the world, is that the Supreme Court in Israel, I'll say it, is a judicial tyranny. It is a quintessential tyranny. When you have people who are appointed on a basis that is incestuous, that are appointing people who are like-minded, you have basically a cabal. And if they don't like Netanyahu, or if they don't like the deal that was made, or if they don't like a military decision, or if they want a social policy decision or whatever, they hide behind the word reasonableness. If it's reasonable, of course we're going to rule this way. And if it's unreasonable, of course we're going to rule against this. So it's kind of a moving, wandering, lawmaking authority without any of the legitimate basis for being a lawmaking authority. Is that correct?
That's correct. And to follow up on the Military Act, this is Posner, and this is the last most outrageous example of how the Israeli Supreme Court tramples on the rights of Israeli citizens, that they have the right and have directed the government to move the security wall that keeps suicide bombers from entering Israel from the West Bank, completely untethered with any principle or democratic structure. It is just how they feel.
And what is the super knowledge that this handful of lawyers who appoint themselves as Supreme Court justices effectively, where do they get all this brilliance from, all this knowledge from? They don't have ministers, they don't have experts advising them. They get them from wherever wherever left-wingers get them, in their own imagination.
Yes, and I want to, at its best is, God talks to them, and they communicate what God says to others. Now, in the Sanhedrin, the old lawmaking body of the people of Israel, there was at least the commitment to Torah, to the core principles of the Bible. Here, it is untethered even to that. It is the Age of Enlightenment purified of humanity or dissent.
All right, Arthur Ferguson, I want to thank you very, very much for your observations. We much appreciate it. And ladies and gentlemen, I want to thank you for watching LevinTV, and we'll see you next time. Be well.